Is Bobby Whitehead. I currently serve as a lead Title IX investigator at the University of Alabama at Birmingham. What I would like to do, if everyone could, is just put in the chat briefly what your connection to Title IX is, and if that is nothing, that's fine. But that will give me a little bit better of an idea of who we've got in the room with us, so I can maybe further explain any acronyms that I use that might not be widely understood. Okay, perfect. So some people that are investigators. Not the Title IX person on my campus. I love that. Okay. Okay. So seeing that some people have already put that in, and others of you I know are actually from my office, so I know who you are and what you do, I'm going to go ahead and get started with the presentation here. So sorry, y'all. This is my first time using this platform, so I am still getting used to it a little bit. If you guys can see the PowerPoint, please give me a thumbs up or just let me know. Yes, perfect. Okay. All right. So this is called Babies in Bathwater. It is a comparison and contrast of two Title IX processes or procedures, and we will go ahead and get started. Like I indicated previously, essentially our presentation is going to go over a brief introduction of who I am. We're then going to start on a hypothetical case summary. We'll then have a progression of that case under both. The slides are a bit small. Okay, thank you, Abby. Let's see if I can make that a little larger. So sorry, y'all. In doing so, I've made it to where I can no longer see anything you guys are typing. Was that better, Abby? Okay, perfect. I can go back to that view. I will not be able to see what you guys say when I'm in that view, which is unfortunate, but I will be checking the chat periodically throughout. Okay, so we're going to have an introduction. We'll then go over a hypothetical case summary. We'll have a progression of the case using both former and current procedures that we use in our office. I'll then talk about some significant differences between the two procedures. I'll talk through some key takeaways and then finally some suggestions, and there will be a little bit of time for questions at the end. So a little bit about me. I currently serve as the lead Title IX investigator at the University of Alabama at Birmingham. I've been in this role for a little over a year. I've been here at the university for a little over 2 years. My prior experiences included working in student conduct, residence life, career services, and academic support services, and that was at roughly 5 different institutions of various sizes. So I've worked at small, very, very small private institutions. I've also worked at large public institutions and a little bit of a range in between. Some disclaimer to the information I'm going to provide all of you guys this morning. The information in the hypothetical case is completely fictional. The names, locations, all the other information was fabricated by me. I do want to note that the information presented does represent what could be an incident based on my experiences. And so if there are aspects of the hypothetical case that you're like, oh, that sounds like something I know about, that's frankly because the examples that I'm using are pretty broad. And you should not take that as an indication that, oh, I know this case he pulled that from. It's highly unlikely that you know what case I would be talking about, again, because it's a made-up case. The processes that I'm utilizing are the University of Alabama at Birmingham process, and that's primarily due to my familiarity with that process. But I would like you guys to go ahead and imagine how any of these hypothetical examples would play out on your campus or at your institution. And finally, all the opinions that I'm going to give are my own, and they are not intended in any way to represent the opinions of UAB or the Title IX office at UAB or any other of my colleagues in the Title IX office at UAB. I'm going to take a moment here just to check the chat and see. You say, oh, we can't see the slides anymore. Okay. Is that still the case, Abby? Can you still not see the slides? Okay. Let's see if I can adjust that. Okay, are you able to see? You should be able to see the slides now. Give me one moment, y'all. I'm just going to double check that you all can see the slides. Yes, perfect. I'm only getting a loading symbol. Rebecca, I don't know what's going on with that. Other people have indicated they can see it. So I'm just going to double check that we can. Okay. So again, all opinions given are my own. So our summary of the hypothetical case. The complainant is Jane, made up name. Jane is a cisgender female undergraduate student enrolled at South Upstate University, which again, I believe is a fake university. If it does actually exist, that was not intentional. Jane is enrolled in one course at UAB with the respondent, Rob Realman. That is a shout out to The Good Place if anyone's familiar with that show. And Rob is a cisgender male undergraduate student at UAB. UAB here is being used simply because I'm using our processes to talk about this, but it is a somewhat fictionalized version of UAB. In this hypothetical case, there were 7 witnesses, and we'll talk about how those witnesses played out. So made up name and Realman matched on Tinder, which for anyone who is unfamiliar, Tinder is a dating application. And they both attended a university event together in person. And so we're going to assume that all of this happened pre-COVID. And then spent the night together in Realman's on-campus apartment. So that would be on campus at UAB. Made up name and Realman consumed alcohol and kissed. Made up name stopped the sexual activity twice and told Realman she did not want to engage in sexual activity because she had a boyfriend. Made up name then spent the night at Realman's apartment on campus, and the next morning, Realman initiated sexual touching and kissed made up name. Realman then began performing oral sex on made up name, at which point made up name said she did not consent and verbally stated no, at which point Realman stopped the sexual activity. So what we're going to do now is a comparison. And this comparison, I want to be really, really clear, is comparing our former procedure versus our current procedure. It is not comparing a good versus bad, and it's really not making any values-based judgment on what is good in the new procedure versus good in the former procedure, or bad in the current procedure and bad in the former procedure. It really is just going to be a comparison between the two in terms of how they differ from one another and how they remain the same. I'm going to minimize now just for a moment so I can see if there have been any questions. Okay, so it looks like there are no questions, so I will go ahead and maximize this again. So our former procedure existed roughly between 2016 and 2020. There were some modifications made to it throughout. But the current procedure was really created in response to the final rule that was issued by Department of Education in August of 2020. So the initial disclosure under the former procedure, Made up name disclosed to, I'm going to use some acronyms here, so I'm going to go ahead and spell those out. She disclosed to the Title IX coordinator at her primary institution, which was that Southern Upstate University. The Southern Upstate University Title IX coordinator reported the incident to the Title IX coordinator at UAB. And then the UAB Title IX coordinator spoke with Made Up Name. Made Up Name requested postponing the initial assessment, essentially until after the break between fall and spring semesters. Made Up Name and an advocate, which was the term used at the time for Made Up Name, contacted and actually spoke to a UAB Title IX investigator. Now, this occurred roughly a week into the new semester, at which point the Title IX investigator began the investigation. Under our current procedure, the way this initial disclosure would work is that Made Up Name, we likely believe, have every reason to believe, would still disclose to the Title IX coordinator at her primary institution, so at SUU. But then we get some differences, and those differences are delineated here in red. The Title IX coordinator at UAB or a designee would meet with Made Up Name and their advisor, and that the advisor is the new terminology that we're using based on the final rule. It very, very clearly would likely not be an investigator completing this initial disclosure. And really that process is to get more information and explain the process because we know that then Made Up Name has a choice. She can either file what's called very formally a formal complaint, or she can request that she only receive supportive measures. Now, one of the keys I do want to point out here is that we would provide supportive measures regardless of, whether she went with the formal complaint. But if she only wanted to do supportive measures, that would be available as well. And that is a difference between the current procedure and the former procedure, is that one, it does require a formal complaint to move forward with an investigation, and if there is no formal investigation, we can still offer supportive measures. The preliminary inquiry phase in our former procedure, this would likely be completed by the Title IX investigator or a team of Title IX investigators. And it would likely be completed in conjunction with the initial complainant interview. So the way we operated was essentially to kind of get all of this done at one time under our old process. Under our current procedure, first, we would have to have a formal complaint, and that formal complaint would be reviewed by the Title IX coordinator at UAB. And the Title IX coordinator would complete an initial assessment, essentially looking to see if there was anything that would result in either a mandatory dismissal or a permissive dismissal of the formal complaint. We're not going to get into all the different reasons that a complaint could be mandatorily or permissively dismissed. We're going to make an assumption here that there is no reason for dismissal, and we're going to go ahead with a formal complaint. But one of the things I do want to point out is that if the complaint was dismissed, there are opportunities for appeal under our current procedure that would not have been available under a previous procedure. Reelman would be notified of the formal complaint at this point. That would be the first notice that Reelman has of a complaint being made or an allegation being made that he had violated the policy. And that would be the first notification. That is additionally a difference between our current process and our old process or procedure. If the complaint was not dismissed, there are options for either an informal voluntary resolution or a formal investigation. We're going to make an assumption here, or I've made an assumption here, that Made Up Name does not wish to pursue an informal voluntary resolution, and she does wish to move forward with a formal investigation. Are there any questions so far at this point? Okay, seeing none, I'm going to continue. So the resolution process, under our former procedure, the notice of investigation was sent to Reelman and Made Up Name after Made Up Name's initial interview. This would have been the first notice to Reelman after in our former procedure, and that is a pretty big difference. So this, in all likelihood, would have been roughly at a minimum 5 or 6 days after the initial interview with Made Up Name, the complainant, that the respondent would have gotten their first notification. Under our current procedure, that would not be the case. So we talked about the formal complaint, the notice of formal complaint being the first opportunity for notice that was sent to Reelman. That would not have been the case under our former procedure. So the investigation itself would have formally began roughly 4 days after notice of the investigation. And again, these numbers are made up, but they're based on my personal experience of what was pretty typical at the time. So this formally would have began 4 days after the notice of investigation was sent out. Again, we likely, as the investigators, would have already met with the complainant and had some information. The interviews would have included 7 witnesses, and under our formal procedure, I'm going to make an assumption here that one of those witnesses wished to remain anonymous, which was fairly common in my experience. And in that former procedure, the investigators collected 15 pieces of individual evidence, and those included impact statements from both the complainant and the respondent. Under our current procedure, the notice of investigation is going to be sent to Reelman and Made Up Name. However, again, this will not be the first notice that Reelman has that he's being essentially accused of a violation of our policy. The investigation would begin no sooner than 10 days after the notice of investigation is sent. And this is something that is required under the new final rule. And it is a fairly significant difference, particularly in regards to time frame from our former procedure. Interviews would include, I'm going to again assume, the 7 witnesses. However, none of these witnesses would be allowed to be anonymous. And we'll talk a little bit more about that when we get to the adjudication phase. Obviously, anyone can come in and give us a statement. However, under the new regulations, we are not essentially permitted to use that information largely unless it is crossable during the adjudication phase. Again, we're going to talk about all 15 individual pieces of evidence, including the impact statements, largely remaining the same. But it is important to know that all of the information collected during the investigation is going to be provided to parties in that final report that is compiled by the investigative team. That is a difference between the current procedure and the former procedure. However, it's a difference really insofar as we're not excluding a lot of information anymore that we might have previously excluded if we determined it to be completely irrelevant. What we would be doing now is really talking through if we excluded something very, very, very purposely, why we chose to exclude it. And we really need to have some very good reasons for excluding evidence, even evidence that may not be initially considered relevant. I'm going to stop here for a moment and just see if there have been any questions. It says there are 2 requests in the queue. I'm not entirely sure what that means. Sorry, again, learning how to use this platform while we're doing it to an extent. Okay, I'm not seeing any questions in the chat, so I'm going to continue. So our adjudication section. Under our formal procedure, the investigator or the investigative team made an investigative finding. So this was essentially a recommendation that we made, including sanctions that would have been then presented to the respondent and the complainant. If the respondent and complainant were not comfortable with or did not agree with the findings, we would then move to hearing, but we did make an investigative finding. And so under our former procedure, I'm going to assume that we would find Reelman responsible for each charge. We would then go to a hearing, assuming, again, that Reelman contested his responsibility. The hearing would be done by panel, and this typically for us included 4 members or 3 members in a chair, so 4 individuals. There was no cross-examination. All questions had to go through the hearing chair. And of those 7 witnesses interviewed, I'm going to say that 4 witnesses would be present and actually gave in-person statements. One of the keys here is that all 7 witnesses would have their information provided would have been allowed to be used in order to make a determination or a finding, which is not the case anymore. And I'll talk about that briefly. The notice of findings would then be sent to Reelman, and we're going to assume that he would be found responsible for each charge. He's then given an opportunity to appeal both the finding and or the sanctions. The sanctions would be included in the notice of findings. If Reelman was found not responsible, there's also an opportunity for the complainant made up name to appeal the finding as well. Under our current procedure, and this is a very large change, there is no investigative finding whatsoever. So all the investigative report is doing at this point is compiling information to then give to the decision maker at hearing. So our hearing process, we now have a single decision maker. We do allow, as is required, for cross-examination. Witness information is really only used if it can be crossed. And so, for example, if someone came in and gave me a statement and then decided I don't want to participate at all in the hearing process, it's pretty likely that their information, at least in large part, would be unable to be used simply because it wasn't ever crossed. There was no cross-examination possible. And that also goes for evidence as well. So if someone, for example, gave a written statement, even though we have the written statement in front of us, we can't really cross that written statement, or a complainant or respondent can't cross that. So we're going to assume that Reelman was found responsible. We're also, and I did want to mention, sorry, going back for a moment, the 7 witnesses that I mentioned, in our initial former procedure, we had one of those witnesses being anonymous. Again, because that would not, you can't cross an anonymous witness. You can't cross someone who has not, is not willing to be present and lose that anonymity. You really can't have an anonymous witness in our current procedure. We're going to assume that Reelman is found responsible and would then be sent a notice of findings. Reelman's then given an opportunity to appeal. If he was found not responsible, there is still that opportunity for the complainant made up name to appeal through an administrative review. So some final actions, and this is really essentially how we're resolving when I say final actions. So under our former procedure, Reelman was found responsible for each charge by a hearing panel. We're going to assume that he would appeal that decision. And so the appeal would be made to the Vice President for Student Affairs, or a designee. That could be one of the assistant vice presidents. And we're going to assume that the reason Reelman wanted an appeal was that new evidence became available. Under our former procedure, the decision that was made by the hearing panel was upheld on the appeal. And that's, again, an assumption that I'm making. So the Vice President for Student Affairs upheld the decision made by the hearing panel. Under our current procedure, Reelman would file for an appeal, is found responsible and then files for an appeal. I have delineated the reasons for appeal here. So one being the existence of a procedural irregularity that would materially affect the outcome of the matter. Second is the existence of new evidence. So again, this largely has not changed. The evidence would need to be something that was not reasonably available at the time the determination was made, or the dismissal was made that could affect the outcome. The Title IX coordinator, investigator, or hearing officer had a conflict of interest or a bias that affected the outcome, and or the recommended sanctions were either severe or too lenient. And this is an important point that I want to make here, is that the complainant would also have an opportunity to appeal as well. So these appeal offerings or options are available for both parties. Assuming that there was an appeal, there would be an admin review of the findings. If the findings are affirmed, or if the appeal is affirmed, the sanctions would then be implemented. If the finding was remanded, the decision maker would be essentially given new instructions to consider, and would then make a decision in consideration of those new instructions. Or the appeal officer may modify the decision maker's decision on their own, and or the sanction. So if they believe the sanction was too severe, they could not essentially send it back down for a new decision. They could modify the sanctions on their own. All right, I'm going to come out for a moment just to see if there have been any questions whatsoever. And seeing none, I'm going to continue now. Okay, so some significant differences between our former procedure and our current procedure. One is the initial assessment. So it's going to be completed either by the Title IX coordinator or a designee. Now, I want to point out here, it could be completed by an investigator. However, that's extremely unlikely. The formal complaint is something that is fairly new, at least in the kind of structural sense. The complainant would then be given a choice. They could either request to do a formal, or they could either do a formal complaint, or they could simply request supportive measures. So we don't have to have a formal complaint to do supportive measures anymore. And changes in the initial notice given to the respondent. So again, under our former procedure, initial notice was given essentially by that notice of investigation. Under our new procedure, the notice is going to be the notice of allegation. So it's going to come significantly sooner, and really before investigators have any opportunity for starting the investigation. Opportunities for appeal if a formal complaint is dismissed. This is something that is new. So obviously, because we didn't have that formal complaint step that was necessary, there wasn't really any opportunity for appeal under our formal procedure. Now there is for both parties. The option for informal voluntary resolution is now significantly more spelled out, but I'm not going to go into detail about that, because that could actually be a full day of training just for informal voluntary resolution or more. But I do want to point out that that option is now much more clearly delineated. There are some new investigative practices, primarily due to time frames. So we cannot begin initial interviews or really collecting any information until 10 days after that notice of investigation has gone out. And so that does obviously lead to processes to some degree, at least, seeming to take longer, because we're not able to start as soon as we had been. Witnesses are being informed of the need for cross, and so there is no anonymity anymore. That's one thing that I'm doing particularly in terms of just making sure individuals are informed that they will need to, if they want the information they present to me to be considered, they will have to then come, if there is a hearing, and present that information again. And the hearing has some significant differences as well. So we are using a single decision maker. That is not required. You can have multiple people on that panel, but we are using a single decision maker that is not the Title IX investigator. And we are allowing, as is required, for cross-examination. And I'm not going to go into the details about cross-examination, because, again, that could be another topic as well. Some key takeaways. One of the big things that I want to point out is that the details, even though we spent some time talking about the details of the hypothetical case, the details of the case don't actually matter at all. So what we're really talking about here are the differences between the processes. Both of these processes are compliant for the regulations under which they operated. Most of the process didn't change. And so, you saw very, very little red in comparison to the black on those previous slides. And I do want to point out, because I know there has been a lot of, for lack of better words, trepidation and consternation over having this new process. And I'm not going to get into the discussion of how good is this, how bad is this, how problematic or not problematic. But I do want to point out that there are positive aspects, at least in my opinion, of the new process. One being additional appeal opportunities, and that's for both the complainant and the respondent. I think appeal opportunities are really, really great because they allow the pressure to be a little bit more off of one person. So if you're under a formal process, if you're an investigator and you're making a decision, I know for me personally, it was always a lot easier to make a decision knowing if someone doesn't like this, they can tell someone they don't like this. And so I think those additional appeal opportunities are always a good thing, just for some oversight. Again, the informal voluntary resolution being much more spelled out, I think is a very, very positive aspect. My personal experience has been oftentimes people will say things, complainants and respondents will say things, well, is there any way we can do this without an investigation? Is there any way I can get what I want without an investigation? I just don't want to have to go through an investigation. And the answer now is yes, and a pretty spelled out way of going through that process. And again, lastly, and this is maybe more an individual benefit, it does possibly put less pressure on an investigator because we're not making those decisions anymore. We're not being asked to make a finding in any way. All right, I'm going to stop here for a moment and just see if there are any questions up to this point. Okay, and again, seeing none, I'm going to continue. So some suggestions I have, and yes, these are all pictures of my son. That was done intentionally, both to put me a little bit more at ease and to maybe buy some brownie points with anyone who enjoys pictures of cute children. But suggestion number one is to use the right size tub. So one procedure will never work for every institution. And I want to be really, really clear about that. So we were given federal regulation from the Department of Education, but one thing they did not do is say, this is the process every institution will use. This is exactly how it's laid out. Everyone has to do it the exact same way. That was not done in that final rule. And the final rule does leave room for what is termed, and I quoted here, discretion of the recipient regarding certain aspects of procedure. So for anyone that has not yet read the 2,033 pages of the final rule, that phrase comes up actually quite a bit. And I believe that that's a really, really good idea because, again, having worked at various institutions, having worked in Title IX at various institutions, what works here at UAB would likely not work even at a very similarly situated institution because, as we know, we're all pretty unique in how our campuses work. And, while you might be able to kind of take and pick from certain things, you probably cannot just take one procedure wholesale and make it fit the mold of your institution. My second suggestion is going to be keep checking the water, as it were. And so this really just means continuously looking for ways to improve your process. So I'm a big believer that if something does not work, just because you've written it down does not mean you can't go in and tweak it. If something is possible to change it if it's not working for you. And obviously you're going to want to do that with consultation and not do it in a vacuum. But again, if, just because you've committed to something, please don't think that doesn't mean you can't go in and tweak it. One of the ways that I think is best to check and see how a process both is working and just frankly how a process feels is getting feedback. And so that's going to be feedback from participants in the process, so complainants, respondents. I would also encourage seeing if you can get feedback from advisors, seeing if you can get feedback from witnesses. And this really needs to be done at each step of the process. So as an investigator, I want to know, how am I doing this? Is my interviewing technique something that, rubs somebody the wrong way? If I'm asking questions in a way that seems hostile or aggressive, I want to know that so I can get better at doing my job. And so we have a better process. That would also go for the supportive measures that we're offering, right? If we're, if we've got a potentially someone who is doing supportive measures and they're checking in via email every day, that may be great for some people, and it may be really problematic for other people. And so I think we're only going to know that if we're asking for some kind of feedback. And then I would also encourage asking for feedback from other trusted sources. So this could be your university's legal counsel. This could be, getting an outside person who maybe also does Title IX work or similar work to look at your process and just kind of see like, oh, this is how this initially reads to me. One of the fun things about working in Title IX is that sometimes we get in our bubbles and we can assume that everyone understands a process because we understand a process. And then later we find out that someone didn't even understand the words we were using to describe the process, much less the process itself. And so I think it's always important to just try and get that feedback from other people. One suggestion, my third suggestion, is keeping the soap out of their eyes. And really, this is just intended to be a moment where we step back and remember that we are working with real people who have real concerns and they need real support. And so I'm going to encourage you not to make the process harder on either yourself or anyone else involved by creating unnecessary additional burdens. I do want to give a shout out to my supervisor, Nathan Perry. He constantly helps me remember not to do this. So including things like timeframes that aren't necessarily mandated in the regulations or even in your own processes, making unnecessary steps that aren't regulated, making any kind of overly complicated forms. I really would encourage you to just look at your process and see what have maybe I artificially included here. So I'll give an example that I tend to do. So I sometimes will put an email or put in an email for an interview request. If I don't hear from you by X date, we'll assume that you don't want to participate in this process. And in doing that, one of the things that I have to be aware of is that I've now created an artificial barrier. For myself, or an artificial time frame. Nowhere in the regulations does it say, hey, you can't, present new information if you don't do it by the time frame the investigator said you had to do it. No, that does not exist. And so if I say that in an email, what I've done, one, is made it to where I've really just made something up that is not enforceable. And two, there's no real need for it. So I've created this artificial barrier that really didn't have to be there. And ultimately what I've done is just made this work harder for myself. So as much as possible, try and keep everyone in the process happy, or as happy as possible. So lastly, and this really is kind of the theme and the key to all of this presentation, is don't throw the baby out with the bathwater. And so we don't really know, people can make countless estimates, and I think most of those estimates are based in a degree of understanding, but no one really knows what's going to potentially change given a new administration. What I would suggest to you is, regardless of if there are changes, if something's working and you're not required to change it, keep using it. And so, for example, the additional opportunities for appeal. I think as many appeal opportunities as we can give someone within reason, that's great. And so, again, just because you have something and maybe they say, hey, you don't have to do this anymore, just because you don't have to do something great, if it's great and you can keep doing it, keep doing it. In all likelihood, both you guys and I can speak for my office. We've got language and frameworks now that have been developed that are likely really scrutinized. And so if it's good language and if it's good framework, don't throw away all the good work that you did just because you might get some changes. They're also likely useful in other areas of equity and compliance. They could be useful in Title VI work or in Title VII work. And so I want to encourage you to think outside the Title IX box and really work with those other campus partners that we have to make sure that we're all using great language and using great frameworks. A lot of emphasis has been put on Title IX, and one of the benefits to that is that we've had a lot of really smart people looking exactly at what we need to do in order to be the best version of Title IX at our institutions that we can be. And we don't need to just keep all of that. We need to spread that wealth, as it were. And then lastly, this hypothetical case was resolved appropriately using each procedure. And so, there weren't any problems necessarily in how the resolution happened in either procedure because the procedures worked the way they were designed to. And so I would encourage you just to keep in mind that, again, if you have something you like that's working, if you had something you liked under a former procedure that was working, as long as it's not required to be changed, feel free to keep it. And really that is where I'm going to end that today. So I do have some time now for any questions. It is 10:42. And so I wanted to see if anyone had any questions. I'm going to leave this slide up a little bit, but I will also tell you guys my email address is bobby.whitehead@uab.edu. If you would like this presentation, I'd be more than happy to send it to you or answer any other questions offline if you don't have any right now.